Sathe, Advocate General of Maharashtra, in charge Vice Chancellor and Distinguished Professor of Emeritus, Honorable Professor A. Lakshminath, and respected Registrar Dr. Dhanaji Jadhav. It gives me immense pleasure to welcome you all to the Deeksharambh 2026 at Maharashtra National Law University, Chhatrapati Sambhajinagar. Today marks the beginning of a remarkable journey of our newly admitted students of BA LLB, BBA LLB, and LLM program. It is not merely the commencement of an academic program, but the beginning of a lifelong pursuit of justice, knowledge, integrity, and service to society. Dharma protect those who protect it, that is, Dharmo Rakshiti Rakshitaha. This timeless maxim reminds us that justice is not merely an ideal, it is the very foundation of a civilized society. As future custodians of law, our students embark on a journey that calls for integrity, compassion, courage, and an unwavering commitment to constitutional values. Education is the most powerful weapon which you can use to change the world. And in the field of law, education becomes the foundation upon which justice is built and democracy is strengthened. At Maharashtra National Law University, Chhatrapati Sambhajinagar, we believe that legal education is not merely about learnings and precedents. It is about cultivating ethical leaders, responsible citizens, and compassionate professionals who uphold the rule of law and the values enshrined in our Constitution. We are deeply honored to have with us today Honorable Advocate Dr. Milind Sathe, Advocate General of Maharashtra, as Chief Guest. His distinguished career and unwavering commitment to the rule of law serve as an inspiration to every aspiring legal professional present here. As we know, every auspicious beginning is marked by seeking the blessings of Almighty and invoking the light of wisdom. The ceremonial lighting of lamps symbolizes the trump of knowledge over ignorance, wisdom over uncertainty, and justice over injustice. May I now respectfully request our dignitaries to kindly proceed for the ceremonial lighting of lamp. So much. It is now time to extend a token of our respect and gratitude to our distinguished guest. May I request Professor A. Lakshminath sir to welcome our today's honorable chief guest, Advocate Dr. Milind Sathe sir, Advocate General of Maharashtra. Thank you so much, sir. To formally welcome everyone and set the tone for today's program, I now have the privilege of inviting Honorable Professor A. Lakshminath, sir, for the welcome address.
I heartily welcome our beloved and honorable chief guest, Dr. Milind Sathe sir, a man of academic excellence and professional expertise, and a learned Advocate General of Maharashtra, who has been here taking out time to give you, in fact, the best from the bar as well as the bench, because he is the one person who has got experience both the bar and also the bench, because he is the bridge between these two. And I need not have to elaborate the functions of Advocate General. But as I could see, he has been a very well-reputed Advocate General representing the government of Maharashtra in both the courts, Apex Court and the High Court. I also welcome, of course, I need not welcome our faculty member, they are the hosts, but my colleagues, and I heartily welcome the parents of the new batch who have joined very recently in the first year of LLB course, if the parents are here. And I also welcome the first batch, the latest students who have joined. I heartily welcome them. And well, friends, I congratulate you for having joined this university, because this university, as far as the main aim of the Bar Council of India is concerned, particularly legal education, it is by the collaboration of three entities, we can say. One, the legal academics, and the bench, and the bar. This triumvirate is solely responsible for the legal education, and particularly in Maharashtra, where there are some 3 law universities, and the government has high hopes, and therefore it has invested very heavily as far as our university is concerned at Chhatrapati Sambhajinagar. So we have all hopes that you have to make a ridge between Siksha and Deeksha. In fact, as for the UGC requirements, not only for the UGC requirements, but it is a good blend of Orient and Occident. The Orient, particularly we people in the East, orient the students, and we initiate them to learn by means of Deeksha, and thereby they go ahead for Siksha. Because this is a good moment where they have to dedicate themselves to the studies. And here you have to go from Prayas to Shreyas, and from cosmos to nomos. In the sense that from Purushartha to Dharmashastra. In the sense that you have to see that the main aim of legal education is not merely to study, but to develop a critical approach towards the law, and how the law ultimately plays a role in the society. That's why it is a combination, a unique combination of legal education, legal research, and its social commitment. That means a lawyer, that's why, is said to be a social engineer. He is the person, and particularly the Gen Jed or Joomsters, Gen Jed. They have to be, and I am very happy that the students here are most disciplined. I could see that. And this is one of the most important factors now that lends for particularly the legal learning. Because this is the period, whether it is for LLM or for LLB, a 5 years course is such that it orients you. This is the beginning, and today it is a formal induction in the sense that you are formally admitted to this institution, and you all come from different backgrounds, from different areas, and you have to coexist with the other people so that you can make your life and education more meaningful and rewarding. And its main concern is to get wisdom. Knowledge is one of the capabilities which enhances the unity. And ignorance is that which always enhances hatred. So we are meant to be mature people, and from information to knowledge, and from knowledge to wisdom. And you see, we have to become legally wise so that we can play a very important role in societal relationship. And law cannot be isolated study as far as society is concerned. With so much of progress, now you can see artificial intelligence is going much beyond whether you see law will be able to control it or not. And artificial intelligence can be a very good slave, but we can't see we can't make it a master. I think Professor Vajay will agree. Who said, you never trust AI. Of course, nowadays, no courts are insisting more on AI. But there is a towards for a learned advocate then also will agree with me. It should not outward you. It should not outwit you. So human being always superior. Artificial intelligence should not be superhuman. This is the caution which was given by the greatest scientist of this century, that is Hawking. So with this in a few words, I think I don't want to take much time, because this is the where you have to get yourself, attune yourself to this atmosphere and see that we work together, we learn together, we go together. And as Sanatana says, Om Sahanavavatu, Sahanau Bhunaktu, Sahaviryam Karavavahe, Tejasvi Nama Dhitamastu, Ma Vidvishavahe. That is the most important. Let us not develop envy. Let us not develop hatred. Let us work together and let us try to improve our knowledge. And with these few words, I request the chief guest to speak on this. Thank you, sir.
Thank you, sir, for your inspiring vision and words of encouragement. Myself, Bhakti Patil from 5th year BLLB, and it is now my distinct privilege and honor to introduce our esteemed chief guest for today's Deeksharambh program, Advocate Dr. Milind Sathe, sir. Sir is India's one of the most eminent legal luminaries, whose illustrious career spans more than 4 decades of distinguished service in legal profession. He completed his Bachelor of Science from DBJ College, Chipraun, followed by LLB from prestigious Government Law College, Mumbai. He secured first class first in his Masters of Law from Bombay University and further pursued diplomas from journalism, social services, and business management. He also holds a doctorate in law with his research focusing on WTO and constitutional sovereignty of India. Having joined the bar in 1982, Sathe sir trained under the guidance of Dr. D.R. Dhanuka before establishing an outstanding independent practice. In 2005, he was designated as Senior Advocate of Bombay High Court, one of the highest professional recognition bestowed upon members of the bar. Over the years, he has appeared before Supreme Court of India and the Bombay High Court, including its Aurangabad and Goa benches, representing clients in numerous landmark constitutional, civil, and commercial matters. His expertise also extends to domestic and international commercial arbitration, and he has served as a senior counsel for the state of Maharashtra, the Municipal Corporation of Greater Mumbai, several other municipal corporations and public sector undertakings. Alongside his distinguished practice, Sir has made a remarkable contributions to legal education. He served as a professor of constitutional law at Government Law College from 1987 to 1992 and has mentored generations of law students as a visiting faculty to several prestigious institutions. His leadership within the legal fraternity has been exemplary. He has served as the Secretary of High Court of Law Library, Secretary of Bombay Bar Association, and later as the President of Bombay Bar Association from 2014 to 2021. He is also associated with several prestigious professional organizations, including the Supreme Court Bar Association, SAC Law, International Bar Association, Bombay Bar Association, the Advocates Association of Western India, and the Bar Association of India. His contribution extend beyond the courtroom through numerous scholarly articles published in leading newspapers, including the Economic Times, Financial Express, Indian Express, and the Daily Evening News India. Today, Advocate Dr. Milind Sathe sir proudly serves as the Honorable Advocate General of State of Maharashtra, the highest law officer of the state, reflecting the immense confidence and trust reposed in his legal wisdom and public service. His life and career stands as a shining example of scholarship, professional excellence, and dedication to constitutional values. For every aspiring law student gathered here today, his journey is a powerful reminder that perseverance, integrity, and commitment to justice are all true hallmarks of exceptional legal career. Sir, it is an absolute honor and privilege to have you amidst us today. And I now request our Honorable Chief Guest, Dr. Advocate Milind Sathe sir, to kindly deliver the induction address and inspire our newest members of MNLU-Chhatrapati Sambhajinagar.
Professor Dr. Lakshminath, Vice Chancellor and also Professor Emeritus of Maharashtra National Law University, Sambhajinagar. Dr. Dhanaji Jadhav, Registrar. My dear professor friends, Professor Lele, whom I know for several years. My dear colleague Amarjit Singh Girase, other faculty members, the parents of the fresh law students who are going to join from this academic year, the veterans in the students category and the students guild, and the administration and the staff of the MNLU, and my dear friends. It is indeed an honor and privilege to be here this morning. Although this university is established 10 years back, and I have been planning to be here for last 10 years, for some or the other reason it has been getting delayed, so I consider myself fortunate to be here this morning. My association with this university therefore has been pending for a long time, but I have had interns from this university, and I have seen the quality of education amongst them, and have been and I must say, great that they have been great students of law, which is a product of MNLU that shows the kind of institution MNLU Sambhajinagar is getting into. It will eventually lead into one of the greatest law institutions in this country. So thank you for inviting me this morning for this program. Dr. Lakshminath mentioned, and the program is appropriately called Deeksharambh. Since it is a residential university, it is like a Gurukul. So you are inducted into a new chapter of your life. Diksha is initiation. Shiksha, of course, for Marathi students, when we start learning Hindi, when we hear the word Shiksha, so we get little dreadful because Shiksha in Marathi means something else and Shiksha in Hindi is education. So Shiksha and Diksha. So Diksha is the very, very appropriate word for initiation into any faculty, any curriculum, any learning, any course. So that's a very appropriate word used for initiation into legal fraternity. So welcome all the young students. You are entering into very distinguished, enchanting, different and challenging world, particularly for the 21st century and 21st century from now onwards. Your generation may not have seen, but Professor Lakshminath and Mr. Girase and me, we have seen such amazing transformation in last 30, 40 years in legal profession particularly and in society in general. When I started legal practice in 1982, we did not have internet, we did not have photocopies, we did not have computers. Just imagine what transformation has happened in last 40 years in legal profession. The stenographers who would type the documents, they would type it, then we would correct it, and the stenographer would type it again and make fresh mistakes. There was no memory to the computer or a typewriter. That's the era from where we have started with the digital era and AI. So that's the legal world now. So that's the world you are entering into. Now, first thing, before you enter into legal profession, which of course decision you have taken, but generally that question arises, why does one want to become a lawyer or why does one want to be in legal profession? There are a variety of reasons. I'm not saying the reason, which is, of course, a humorous reason. The Irish poet Samuel Johnson, his biography was written by Mr. Boswell. And he wrote, quoting Samuel Johnson, that patriotism is the last resort of scoundrels. In 80s, one of the Supreme Court judges had said that legal profession is the last resort of scoundrels. Now, that is no more true, that is no more valid, and legal profession is one of the most sought after legal profession today in 21st century. You young students will not believe when I say that in 80s and 90s, if you go to a bank and seek credit card, lawyers were refused credit cards. If you went to a bank or a housing loan company and asked for housing loan, lawyers were refused housing loans because they were not considered credit-worthy even for a credit card or a housing loan. And now you see where the legal profession has transformed today. That's the transformation, that's the revolution which the legal profession has witnessed. The first Lok Sabha, which was elected in 1952, before that there was of course a constituent assembly which functioned as Lok Sabha between 47 and 52. The first Lok Sabha had 38% lawyers as members. 38% Lok Sabha members were lawyers in the first Lok Sabha. That percentage has been decreasing over a period of time, but still there is a sizable proportion of lawyers amongst the lawmakers, which is an ideal thing to be amongst the legislators and parliamentarians, because that's their job to make laws. So if they're law graduates, it's much better. But that was the importance of lawyers. If you study the history of history of freedom struggle of India, particularly from 1857, it is led by lawyers. So the lawyers have been in the forefront of every civil society movement, including freedom struggle from 1857. So why does one want to become a lawyer? There are a variety of reasons. One is, of course, pursuing legal profession as a career, which would be both two kinds of functions, one as a lawyer and one as a judicial officer in the judiciary. So that's one reason. There are a large number of people, large number of students who want to pursue legal career to get a corporate job or a corporate responsibility and function and climb the ladders in corporate circle. There are several other avenues like international diplomacy. In United Nations and various organizations like United Nations or the UNICEF, UNESCO, International Labour Organization, etc., they all have great avenues available for lawyers. So that's one career diplomat for lawyer available in the international forum. After 1995, when World Trade Organization came into being for resolution of international business disputes in the world, World Trade Organization became yet another important forum for legal profession for resolution of international disputes on variety of subjects. WTO, several of you would know what WTO entails. Particularly the dispute-oriented issue is the TRIPS, the Trade-Related Intellectual Property Rights Agreement, and several other agreements which result into disputes between two nations, two sovereign nations, and those disputes are referred to the dispute resolution body of the WTO, and there is a large scope for the legal professionals. So that's yet another avenue which is available for the lawyers, and that's possibly one of the reasons why some of you may join the legal profession. Then there are several other avenues, like you can become a lawyer, you can get into civil services, the civil services career in India, and if you have a legal background, that helps tremendously in civil services. I now, in my capacity as Advocate General and before, when I used to deal with the government servants for doing government matters, I interact with some of these IAS officers, the bureaucrats or IPS officers, and I find them amazing. Of course, they are bound to be super intelligent, because in an examination in every year, they are the first 800 people selected throughout the country. So they're bound to be smarter and intelligent. But if they are lawyers, if they have studied law, their sharpness and their intellectual capacity to deal with the problems faced by the government and government servants is far, far superior. So that's yet another avenue which is available for the lawyers in civil services. Then there are a large number of other avenues which are available for the lawyers, including joining the politics. If you join the politics as a lawyer, you are definitely going to make a different mark in the career, because legal profession, legal knowledge is definitely superior than the other professionals who join the politics. In Government Law College, when I was studying law, there was one another reason, which of course not the real reason in that sense. In Mumbai, of course, I don't know how many of you know, the Mumbai is a north-south city, and the commutation, most favorite mode of commutation is local trains, and local trains are about 35-40 kilometers, and everybody travels by local train, and we get passes for the local train. They are called season tickets. So several students used to join law college to get concessional railway season ticket. From Virar to Churchgate, you get the railway season ticket at 1/4 price if you are a law student. So they incidentally used to attend a law college, government law college at Churchgate. When I started legal profession, the law college admission was the easiest thing to do, and you could join and go and take admission any time before the first term ended. Now, I must confess that I became a lawyer accidentally. In our families, but I think that's true about all Maharashtrian families, the children are either supposed to be doctors or engineers. So I did not get admission to engineering college because I happened to be the last batch of 11th standard, and the next batch was 10th standard who were to do 10+2 course. So when I passed my inter science after 2 years after 11th, the following batch passed their 12th standard, and both of us were competing for the same number of engineering seats and medical seats. And there were 5 engineering colleges in Maharashtra and 5 medical colleges in Maharashtra, and obviously seats were halved, so our chances to get admission was reduced. Now just imagine that kind of situation happening today, that one course available for 2 years of students. Now there would be what you call Gen Z agitation, there would be protests, there would be PILs, and there would be agitation, but our batch was docile batch, our parents were not very revolutionary. So we had to undergo that, and then that's why I did not get admission to engineering college, and I think I'm very, very happy that I did not get the admission to engineering college. So that time admission was very, very, very easy. So for you, you have to undergo various classes, courses, write the entrance examination, and after that go through those admission rounds, etc. So you have struggled to get the admission, but it's definitely deserving and it's worthwhile, because today legal profession is definitely one of the sought after profession, very respectable profession, and that's really, really a revolutionary change, a welcome change than what I have seen from the early 80s, early 90s, etc. today. So there are large number of avenues available for lawyers, and that's variety of reasons why the students, young students like you, decide to opt for a legal career. Now there are universities like MNLU which create brilliant lawyers. Now I was talking to Dr. Lakshminath, and we're talking about, and Dr. Jadhav, that the law university concept started first time in 1987. The Bangalore National Law University was the first national law university established in India. And I happened to be in that university in 1987. Bar Council of India had conducted a workshop for young lawyers. It was in the campus of Bangalore University where National Law University was being run, and the first batch of students were working there as volunteers when this workshop happened. At that point of time, Dr. Madhav Menon, I'm sure most of you must be knowing Dr. Madhav Menon. He was the founder and pioneer in MNLU, in the establishment of Bangalore National Law University. That time he mentioned that he was creating the National Law University to create better lawyers and better judges. Unfortunately, his dream did not come true. It's a sad reality that Bangalore National Law University, which is now functioning for over 35 years and produced 35 batches of lawyers, most of those lawyers are not in legal practice and not taken legal profession as a career. There are not senior lawyers, not many judges which are produced from MNLU, from the National Law University, Bangalore. That's a sad reality because the National Law University is not for creating another source for recruitment for industry or corporates. They already have enough sources like IIMs and IITs. National law universities are meant for the legal profession, judiciary in this country. And I'm glad that I know for a fact and I was informed that the national law universities in Maharashtra, Mumbai, Nagpur and Sambhajinagar, they are becoming feeders for legal profession and judiciary. And that's a great thing. And in that respect also, I welcome all of you to the legal fraternity and I hope you pursue the legal career in legal profession, not the corporate world, not the corporate job. Of course, these are options and it's an individual choices, but primarily you are meant to be part of legal profession and legal services and judicial services. Now, so welcome to Law University, welcome to legal profession, which is a very, very enchanting word. Now, what is that is available once you become a lawyer? There are 2 or 3 things which you need to note as a law student. There are your 5-year law course, 3-year law course. During these 3 years or 5 years, you must pursue several activities because you are a full-time student, unlike in my time, our colleges used to get over at 9:45. So we were free at 9:45 in the morning, free to do whatever you liked rest of the day till next day morning at 6:45 college for 3 hours. So yours is a full-time course. You must take full advantage of those 5 years to pursue and hone your skills for being a perfect lawyer, or if you pursue the judicial career, to be a judge. Now, there are a large number of things which you should be doing as a law student, which of course the National Law University also takes care of. Starting from learning your writing skills. There are 5 books written by Lord Denning on law, which I would recommend you. They are the textbooks for any law student. The first book in the series of 5 books written by Lord Denning, they are written between 78 and 1984. The first book is Discipline of Law. And his first chapter opens with advice to lawyers. And he says, words are tools of trade for lawyers. And therefore, you must have utmost mastery and dexterity with words. Whichever language you are going to practice, because now practice is in vernacular languages is also permitted in the lower courts. High courts still have English as official language. Let's talk about English only, therefore. The words are tools of trade and you must have them enough in your armory, enough in your kit. The words are vehicles of thought. That is where you communicate in writing as well as your oratorial skill while you address the judges. So words and language, whichever language you are going to practice is a most important tool in your armory as a lawyer or as a judge, and that's what you must practice. The second, of course, is the moot courts which you always have, elocution competition, debating competition. Participation in these activities is critical, not what happens. The preparation itself is the most important part in these competitions and the activities. Whether you succeed, whether you get prizes, whether you get consolation prize, whether you get first, second, third prize, that is immaterial. In these activities, participation is the most important thing. Then the next is internships. Internships not only with the lawyers, courts, etc., but I would recommend the internships including visits to various social organizations like Beggars Home, Old Age Home, jails, Other social service organization like in Mumbai, I am not fully aware of the organizations around Sambhajinagar, but you can always visit the organizations in Mumbai, Pune, etc. And there are large number of organizations. I did a 1-year diploma in social services, and we visited during that year 100 social service institutions like Beggar Home at Chembur, Shraddhanand Mailashram at Matunga, all jails in Maharashtra, Beggars Home in Vasai, Old Aged Home in Vasai. When you visit and interact with those people, you know the realities of life from legal angle. The legal problems these institutions and the inmates of these houses face. There is a society, David Sassoon Society for Youth, that is between 8 and 18 years of age. Boys are kept there who have faced the wrong side of law. So they are in that institution and they are trained there. So the legal problems faced by these institutions, legal problem faced by inmates of these institutions is a illustration, is a study for you law students, and that's not that you will not find in any curriculum, that you will not find in any classroom or any textbook, but that's a life experience you learn by visit to these social service institutions. So I think you should add that to your life as a law student during the next 5 years. So there are a large number of activities apart from, of course, your classes, studies, and examinations. Now, once you become lawyer, what are the avenues available for you as a lawyer in the society? The first and foremost is, of course, legal practice. And you have to make choices in the legal practice, whether you are going to be a civil lawyer or criminal lawyer. Of course, you don't need to take that call on the first day. It happens by and by over a period of time. You don't need to take that call on the first day. But you need to make that call whether you are going to practice or whether you are going to take other career option, which is available for lawyer, which I mentioned, like the corporate job, or a diplomatic job, or civil services, or organizations as a lawyer. Or there are other options, like you can be a full-time legal author, you can be a social activist as a lawyer, you can take international diplomacy as a law graduate, etc. These are a variety of options. But if you take the option of legal practice and legal career, then you have two options over a period of time. One is, of course, legal practitioner, and second is the judicial career. Judicial career today is really best available option. Between 1980 and 2010, I would say judicial service in India was not attractive at all. And I will give you an illustration why I am saying so. There was an act known as Government of India Act in 1935, which established Federal Court in India, which became precursor to our Supreme Court of India. And the High Courts and Federal Court judges, in 1937, the Federal Court judges' salary was 4,500 rupees per month, and High Court judges' salary was 4,000 per month in 1936. That Federal judges' salary became the Supreme Court judges' salary under the Constitution from 1950, 5,000 rupees, High Court judges 4,000 rupees. Unfortunately, that salary continued to be 4,000 and 5,000 rupees till 1986. There was no change. A High Court judge was drawing a salary of 4,000 rupees in 1940. He continued to draw the salary. It was reduced to 3,500 under the Constitution. So from 1950 till 1986, High Court judge's salary was 3,500 rupees. The government in 1986, Government of India, amended the Constitution and made a provision to increase the salary of the High Court and Supreme Court judges, and now it is not frozen in the schedule of the Constitution, but it is now provided by the Act, so it keeps on changing with the index connected to it, like what is done to the other civil servant salary, etc. But between up to 86, the salaries were frozen, and that was really a pathetic scene. One of the books which I mentioned about Lord Denning, in addition to that, you must refer to another book written by former Chief Justice of Bombay High Court, Justice M.C. Chagla. The book is known as Roses in December. That is his autobiography. And in that he had mentioned that if you want good judges and them to be independent, one thing, they must be well paid. judges must be well paid, then only you will have an independent, unbiased judiciary. And there he lamented that these judges' salaries were frozen from 1950 till 1986. So today, that is not the situation. Post 2010, the judges' salaries are the best which you can compare with private professionals also. And therefore, judicial service today is not is really a great career option for a law graduates in addition to law. So you take a call whether you want to be a lawyer or whether you want to be in judicial service. Of course, for judicial service, unlike prior to 1950, that option is not available today. Up to 1955, the moment you passed law degree, you could write judicial services exam and become judge without even practicing for one day. Today you need to practice for 3 years before you take the Civil Judge Junior Division and JMFC examination. And therefore, that option you can take within a period of 3 years. But that's a great option to have today. Once you decide to become a lawyer and not go for judicial service, then you have options of civil or criminal practices. In civil practice also you have to decide courts, and I would indicate what the hierarchy of the courts in which many of you possibly would know. On civil side in our country, unlike very complicated judicial system in some other countries, our judicial system is fairly simple. It starts at taluka level on civil side with Civil Judge Junior Division. Then the next hierarchy is Civil Judge Senior Division. Then there is a district court. Then there is High Court and the Supreme Court of India. That's the 4-tier civil courts in our country. Similarly, the criminal courts start at taluka level from Judicial Magistrate First Class. Then there is Sessions Court, then there is High Court and the Supreme Court of India. Again, 4-tier system on criminal system. So these are the courts available for you to practice. Fortunately, our Advocates Act, Section 30 says that once you are enrolled as an advocate with the role of any bar council in the country, this is a great right which is conferred on all advocates under the Indian Advocates Act. You can practice in any court before any tribunal in the country without anything more. Some of you who may be familiar with the American system, in each state of America, those 52 states, each state has its own bar examination, and a lawyer from one state cannot go and practice in another state unless he passes the bar examination in that state. Unlike that, in India, you have one bar examination and you can practice before any court in the country, including Supreme Court of India and all tribunals where legal representation is allowed. Incidentally, Pakistan is not known for the great judiciary or democratic system, but as a member of SARC law, I happened to visit Pakistan in 2004 and I found a good thing which possibly we could emulate in our country. In Pakistan, before you start practice in High Court, you need to have practiced in District Court for 7 years. You cannot practice in High Court directly unless you practice in the concerned District Court for 7 years. And you cannot practice in Pakistan Supreme Court unless you have practiced for 5 years in High Court. So you can appear in Pakistan Supreme Court only after 12 years. Fortunately for us, the moment you pass, next day you can go and appear in Supreme Court of India. Whether that's good thing or bad thing, that is for the bar councillors to decide. But I think it's a good thing. There should be some training before you actually go and appear before the Supreme Court. And the best training ground for lawyers is the subordinate courts and the trial courts. That's a learning curve. That's the learning curve which you know in the lower courts that you will never forget. And that's something everybody must start. The practice in trial courts, the lowest court, is a great practice to start with, even though eventually you want to practice in the High Courts and the Supreme Court. But that exposure to the trial court is really, really essential and important, and I think all of you should consider that option. So that's the court hierarchy. So you can practice in any court. In addition to that, we have large number of tribunals in our country. In fact, there is a criticism about tribunalization of judiciary in our country. The tribunalization started in after 1976 when 42nd Constitutional Amendment was enacted, and it introduced Article 323A and 323B in the Constitution for making provision for establishment of tribunals for judicial work. And the first tribunal which was established under that provision was the Central Administrative Tribunal for Central Services and the State Administrative Tribunal for State Services Disputes. So that's the first tribunal. Since then till today, there are at least 25 specialized tribunals, and you can consider practice before those tribunals as a specialist of that particular subject. For example, we have Green Tribunal under National Green Tribunal Act. All environmental disputes go before that tribunal, and that's an important organ of our state today. There is a Telecom Dispute Tribunal, there is Electricity Appellate Tribunal, there is a Natural Gas Appellate Tribunal. So you name a subject and there is a tribunal. Competition Commission, the insurance body, etc. So there are a variety of tribunals where you can practice. And of course there are tax tribunals, Customs and Excise Tribunal, which is known as, earlier it was CGAT, now it is CSAT. Then there is of course the GST Tribunal, and the best functioning tribunal in the country has always been Income Tax Appellate Tribunal, which was established in 1940, even before the Constitution, under the Income Tax Act of 1922. And several courts have acknowledged the functioning of Income Tax Appellate Tribunal. They have their own bar as the best functioning tribunal, and the credit for that was given because the Income Tax Tribunal functions not under the Finance Ministry, it functions under the Law Ministry. So it's not a parent ministry's tribunal like all other tribunals who function under their parent ministry, like Administrative Tribunal function under the Ministry of Personnel, etc., or Green Tribunal functions under the Environment Ministry, etc. Income Tax Tribunal functions under the Law Ministry, and it has been the best tribunal in the country. So for you, there are large number of tribunals which are available under the different acts where a specialist practice, depending on your core subject, depending on your interest, etc., you can decide that forum. In addition to that, we have a large number of other courts under variety of statutes, and I will mention in Maharashtra because you may be familiar or you will become familiar with those subjects. In Maharashtra, there are 36 districts and therefore 36 collectors, and we have about 500 talukas. So each taluka has a tahsildar or subdivisional officer and a collector. And all of them, these tahsildars and collectors, they have large number of judicial functions under variety of acts, like Land Revenue Code is particular, Cooperative Societies Act, and there are large number of acts under which collector is the collector, who is also known as district magistrate. They have several judicial functions to perform, and as a lawyer, you can practice before these authorities also, because at taluka level, if you decide to practice at a taluka village level, there are large number of disputes which are decided by subdivisional officer, tahsildar, or the appellate authority as a collector, additional collector, etc. So these are various tribunals, the statutory tribunals, quasi-judicial tribunals, which function for discharging the judicial functions under various statutes. So that's yet another kind of practice which is available for the lawyers. In 1957, when Maharashtra brought in the Tenancy Act, like you will come across that phrase called Tiller's Day. So 1st April 1957 was declared as a Tiller's Day, and it said any farmer who was in possession of an agriculture land and he was cultivating that land, he was granted the status of the owner of that land. He was entitled to purchase that land as a deemed purchase, and he became the owner of the land. So that is known as Tiller's Day. So post that 1st April 1957, for next 25 years, there was a flood of litigation under the Bombay Tenancy Act, now Maharashtra Tenancy Act. So these are some kind of tribunals or some kind of litigations which open up because of some new enactment, etc. So that's another avenue which is available for the lawyers to pursue the separate career before that tribunal. So that's broadly the career options which are available. This is of course a brief, there are a large number of other options available. I'll briefly indicate to you about the jurisdictions of High Courts and the Supreme Court, which would interest you to take a decision which court to practice. Now, High Courts in our country, or 25 High Courts in our country, though we have 36 states, we have 26 High Courts, 25 or 26 High Courts. The High Court's most important jurisdiction is what is called writ jurisdiction under Article 226 of the Constitution. And it is not really writ jurisdiction. That jurisdiction is to pass any order, direction, or a writ. And High Court's jurisdiction is far wider insofar as writs are concerned than even the Supreme Court of India. Because High Court's jurisdiction is to issue writ or an order or direction for not only enforcement of fundamental rights, but for any purpose. As against that, the jurisdiction of Supreme Court is for enforcement of fundamental rights only under Article 32. So that's one important jurisdiction under Article 226 of the Constitution. In that jurisdiction, you would hear the concept of public interest litigation. That is a concept which was evolved in late 70s, post-emergency, to take the causes which relate to public, which relate to underprivileged, which relate to masses, and those underprivileged persons or that class of people are unable to approach the court, so therefore the public interest litigation was evolved. So you take up a cause on behalf of the society or a particular class and go to court and seek redressal against the grievance. So that was broadly what was known as public interest litigation. And that gave result to large number of persons from 1977 onwards. I will just give you one example. In the case of Hussain Ara Khatun, there was an incident in Bihar. In Bihar jail, some prisoners were blinded by the police authorities, and the matter was taken up by Supreme Court, and Supreme Court issued directions for remedial measures. There was one order passed on a PIL by the Supreme Court entertaining a postcard written by one of the inmates of a jail, and the Supreme Court order, what did the postcard say? The postcard said that a person was in jail for some offense. The maximum punishment for that offense was 7 years, and he was in jail as under trial for more than 10 years. Even if he was convicted, his sentence would have been 7 years. The Supreme Court took cognizance of that matter and directed release of all persons in all prisons throughout the country who had been in jail for a tenure more than their possible sentence. Without anything more, the Supreme Court ordered such release, and that release happened for over 1 lakh persons. And that was the relief granted by Supreme Court in PIL. Just imagine the lawyers who took up this cause, the satisfaction they would have gained by taking up this case and granting relief to such large number of persons. Of course, some humorous things happen about this postcard issue. When clients come to you and you draft a petition of 20-page, 30-page petition, you ask for more documents, you ask for more particulars, you ask to add more paragraphs in the draft petition, etc. The client will ask you, but sir, the Supreme Court entertains postcard as a writ petition. Why do you want to write a 40-page petition? Now, that is something which you need to answer to your client, saying that a postcard being entertained by the Supreme Court is not a substitute for a pleading to be filed in court. And as a lawyer, you must be very, very particular and methodical in drafting your pleadings. And that's why when I said words are your tools, words are vehicles of thought, your pleadings, your writing skills of a pleading are very, very critical, because what you write is your complaint, which is what the other side will respond, and that is what a judge will decide. So as a lawyer, you need to undertake that exercise of a drafting of a proper pleading. So we were talking about the jurisdictions of the High Court. The first I mentioned is the writ jurisdiction under Article 226. There is another jurisdiction of High Court which is known as superintending jurisdiction under Article 227. That is over subordinate courts. So if you are aggrieved by any order passed by any subordinate court, which is subordinate to that concerned High Court, you can go to High Court and seek redressal against the order of that court, which is known as the superintending jurisdiction under Article 227. And that jurisdiction is known as the certiorari jurisdiction. Certiorari is the name of a writ petition, which is of course a Latin phrase. We still continue to use that phrase. Certiorari basically means certification or correction. So you challenge an order of a tribunal or an order of a subordinate court and question its validity on the ground of jurisdiction, error of law, etc., whatever limited grounds are available. And the High Court either quashes that order as wrong order or a perverse order, or certifies it to be correct, that is, does not interfere with that. That is called certiorari jurisdiction, which you will study when you study your constitutional law. So that's another jurisdiction which the High Court possesses. In India, there are 4 High Courts which have original jurisdiction. Original jurisdiction means a proceedings is initiated in the High Court in a civil matter. The Mumbai, Madras, that is Chennai, Kolkata and Delhi. These are the 4 High Courts which have original jurisdiction, that is, you can file a civil suit in these High Courts. No other High Court you can file a civil suit. That civil suit has to be filed in the court of the lowest jurisdiction, either civil junior division, senior division, or the High Court, the concerned High Court. No other High Court has this original jurisdiction. See, the other jurisdictions which High Court possess are company jurisdiction. Of course, now that has been transferred to company law tribunal. So that's one of the tribunal which I omitted to mention. There are National Company Law Tribunal and National Company Law Appellate Tribunal, which resolve all corporate disputes relating to company law and other issues arising out of company law. Insolvency court, the same tribunal functions. So the High Court has this original jurisdiction in 4 courts. The intellectual property disputes for which the suits are filed, these High Courts entertain those disputes as original proceedings. Then there is a testamentary jurisdiction which is in respect of matters of succession, etc. Succession, probate of wills, etc. That also these 4 High Courts exercise. Then of course there is a family law which relates to matrimonial disputes, maintenance, guardianship, etc. So that's another court which is available, the family court, etc. One issue when we talk about the judiciary, judicial freedom and the court system is the population to judge ratio. Ideally, what is considered is for a 1 million population, 1 million is 10 lakh people, there should be 50 judges. Therefore, with our 150 million, 1,500 million population, we need about 75,000 judges in our country. We have 38 Supreme Court judges, about 4,000 High Court judges and 22,000 subordinate court judges. So we roughly have about 23,000 judges in our country as against 75,000 judges which is required for an ideal judge to population ratio of 50 judges to 1 million population. Now, the government is working, the central government, law ministry and the state governments are working towards that goal, but of course that requires a lot of infrastructure, funding, etc. But for lawyers, the judicial openings become a very, very important opening and career option. So if the court number is increased, that would be a big avenue available for the legal career. So once I have mentioned the jurisdictions of the High Court, let me introduce you to the jurisdictions of Supreme Court. Supreme Court also has large number of jurisdictions. The first is the writ jurisdiction, of course, under Article 32, which is for enforcement of fundamental rights. During the Constituent Assembly debates, Dr. Ambedkar, the chairman of the drafting committee, while discussing on Article 32, he said, if he was asked a question, what is the soul of the Constitution? And he said, I would unhesitatingly answer and point out to this article, that is Article 32, as the soul of the Constitution. And what is that soul? That is a right of a citizen to approach the Supreme Court of India to enforce the fundamental rights guaranteed under Part 3 of the Constitution. That is the jurisdiction of the Supreme Court under Article 32. You go to Supreme Court, complain about violation of your fundamental right, and Supreme Court would entertain your petition under Article 32. Of course, it has two conditions precedent. One is that you must be a citizen, and second, it must be only relating to violation of fundamental rights. Other rights violations, you cannot go to Supreme Court directly, you can go to High Court under Article 226. That's one of the important jurisdiction of the Supreme Court. Yet another jurisdiction of Supreme Court is to resolve what is known as federal disputes. Federal disputes means the disputes between two states, dispute between state and union, or dispute between some states and union on one side and some states on the other side. So these are known as federal disputes, and a state can file a suit, civil suit, in the Supreme Court under Article 131 of the Constitution of India. There are a large number of suits so far have been filed. One of the suit which is pending, which you will possibly know about, is suit filed by State of Maharashtra against State of Karnataka and Union of India in respect of the border disputes between Maharashtra and Karnataka, the 5 border districts of Belgaum, Karwar, Nipani, etc. That suit is pending in the Supreme Court of India. That's a federal dispute jurisdiction of the Supreme Court under Article 131. Then there is another jurisdiction of the Supreme Court, that is Article 136, that is special leave petitions. You can go to Supreme Court challenging any order of any court or court or tribunal, challenging that order and seek leave to appeal to the Supreme Court under Article 136 of the Constitution of India. And majority of the work today in Supreme Court, 95% of the work in Supreme Court is special leave petitions against any order of any court or tribunal. Everybody goes to Supreme Court under Article 136. Then there are other jurisdictions under Article 132, 133 and 134 of the Supreme Court Constitution of India to decide substantial questions of law, of interpretation of Constitution, civil law or criminal law. You can either get a certificate from the High Court in a judgment that this particular issue requires the authoritative pronouncement from the Supreme Court of India in a civil matter, constitutional matter or a criminal matter. If High Court gives you that certificate under Article 132, 133 or 134, you can directly go to Supreme Court of India. Otherwise, you have to apply for leave under Article 136 of the Constitution of India. Yet another jurisdiction of Supreme Court is the advisory jurisdiction under Article 143. You and me cannot go to Supreme Court seeking advice. Only President of India can go to the Supreme Court and seek advice. And so far, about 19 references have been made from 1950 till date under Article 143 by the President of India seeking advice on variety of subjects. The latest reference was decided by the Supreme Court was in respect of the whether there can be a gap between more than 6 months between the two assembly sessions because the elections were not held, etc. So that was one of the dispute which was resolved by the Supreme Court in advisory jurisdiction under Article 143. There was one interesting case which happened in 1965 under this advisory jurisdiction. You might have heard about the privileges of the Parliament or the Legislative Assembly. Their privileges are not defined. The Constitution says that the state legislature and Parliament of India will enjoy privileges which were enjoyed by House of Commons on the commencement of the Constitution. They are undefined, they are completely uncharted, and the courts or the Parliament themselves can decide what their privileges are. In 77, in 44th Amendment Act, they changed that saying that parliamentary privileges shall be those which were enjoyed by the houses at the commencement of the 44th Amendment in 1977, again vague, undefined, etc. So in that context, an issue came before Allahabad High Court, one journalist wrote an article which was defamatory or breach of privilege according to the legislators, and therefore they issued him privilege breach notice. That journalist filed, Keshav Singh, he filed a petition in the High Court, and the High Court granted stay of that order. So the Assembly Speaker issued contempt breach of privilege notice to the journalist as well as to the judge of the High Court. The two judges confirmed that order, so the Speaker issued privilege breach notice to those two judges. So overnight, the full court of Allahabad High Court assembled to decide what course of action to adopt. And they stayed the order of the Speaker, summoning two judges of the High Court. The matter could have escalated further, but at this time, the President made reference to the Supreme Court of India under Article 143, and the Supreme Court decided that matter, which is reported in 1965, which defines what are the privileges and the rights of Parliament and state legislatures about contempt, privilege, etc. And that's a classic judgment, which is one of the judgment I would recommend you should read. So these are various jurisdictions which are possessed by the Supreme Court, the High Court which I mentioned. So that's a large and very, very wide spectrum which is available as lawyer for you to practice when you decide to practice as a lawyer in courts and not take the other career option. So that's where you eventually will end up as a lawyer in the courts, which I mentioned, from the civil judge junior division at taluka level to the Supreme Court of India, which you have right to practice. As an advocate, once you become a lawyer, enroll as an advocate under the Bar Council, with the Bar Council under the Advocates Act, you are subject to discipline of Advocates Act. That's a very, very important legislation for every advocate to know, because that's your Bible, that's your Gita. That is what the law is under which you are entitled to practice. That is the law under which your rights and privileges are regulated and protected. You are protected as a lawyer. You are required to have duties to fulfill under that act. So the Advocates Act has two bodies. The Bar Council of a state, which is an elected body by the advocates from that particular state. They elect 25 members and they constitute Bar Council of the state. That Bar Council enrolls you as an advocate and you are responsible to that Bar Council. Misconduct by a lawyer is adjudicated by the Bar Council of the state, and appeal against that order goes to Bar Council of India. Each Bar Council sends one representative to Bar Council of India, and that is how Bar Council of India is constituted, and they frame rules under the Advocates Act. And one of the most important rules which they have framed is in respect of professional ethics, professional etiquettes and ethics. That's your charter, that's your code of conduct which you need to follow. Those rules of ethics and etiquette have 3 chapters. One is your duty to the court, your duty to the client, and your duty to your colleagues. These are the 3 code of duty which are provided in the rules prescribed by Bar Council of India. And one of the most important aspect is you need to be courteous. Now, of course, you need to be courteous in your social life also, but as a lawyer, that's a duty cast upon you to be courteous to your colleagues, to your court, and to the court also. There is a duty cast again upon a lawyer to the clients to be fair and not to conduct misconduct. And misconduct is punishable by Bar Councils, and the punishment could be censure and cessation of practice or removal from the role of Bar Council. Then you cannot practice. Insofar as misconducts are concerned, if a person is convicted for an offense involving moral turpitude, his name would be automatically removed from the rolls of Bar Council. And the offenses involving moral turpitude is a well-known concept. I would give an example which is an offense which is not moral turpitude, like for example, traffic offense or non-filing of income tax return in time or non-filing the return as a director of a company, etc. These are the offenses, technical offenses, which will not be considered as offenses involving moral turpitude. But murder, grievous hurt, etc., those offences definitely are considered as offences involving moral turpitude. If somebody is convicted, her name stands removed from the rolls of Bar Council. So that's one important act you must know, because that is the charter under which you will be practicing, that is Advocates Act, and the rules framed thereunder. The law colleges, the law universities, their curriculum, this all regulated by Bar Council of India. So these are all very, very important bodies that you need to study, you need to understand, and you need to imbibe, because those rules of ethics, code of conduct is what will sustain you in your practice. Now, I'll just briefly deal with one thing which you must remember when you start practice as a lawyer, and I'm assuming most of us, you will start legal practice rather than taking corporate jobs or the other avenues which are available for lawyers. You need to know the legal history of Indian Constitution. And you may not start with Magna Carta of 12th century, but incidentally you should know the story of Magna Carta. Magna Carta was signed by the king in 12th century under duress. Can you believe that? He was forced by the earls to sign the Magna Carta because there was a dissatisfaction between the earls and the king. And that Magna Carta was short-lived. It was rescinded in less than 10 years. It was, of course, subsequently revived, but that's how a big charter of human rights, big charter of civil rights started. It was started under duress. The king was forced to sign that, and it continued. But that's how we recall Magna Carta, or when we say a particular document that this is a Magna Carta of human rights, this is Magna Carta of environmental laws, etc. That's how we consider Magna Carta as a great document. So you need to know little history of what Magna Carta is. And as far as evolution of law in India is concerned, if you don't want to start from 16th century, where actually the evolution of law and courts in India started, when the East India Company Charter was established, and then British, Portuguese and Dutch British, Portuguese and Dutch started trading in India, they had their own courts and they were the charters of those courts. But you don't need to start from there, but you definitely need to start from at least 1857, which is the time when the Indian struggle for independence began, and post that, the East India Company's rule came to an end, and the British government, the Queen, took direct control of the Indian administration, and the laws passed since then is the actual evolution of law in India. The first law which was passed was in 1861, Indian Regulation Act, under which India was being regulated by the British government. And of course, the most important act was Indian High Courts Act of 1861, under which the three chartered high courts were established, that is the High Court at Bombay, High Court at Madras, and High Court at Calcutta. And that is why these three high courts are known as chartered high courts, because a charter was issued establishing these high courts under the Indian High Courts Act. And that is how the evolution of Indian constitutional law began from 1861. Then, of course, there are various Government of India Acts, more notably being Government of India Act 1909, 1919, and 1935, which was the last act known as Government of India Act. Between 1919 and 1935, large number of developments happened. You might have heard in movies or history, there was a commission sent to India for constitutional reforms known as Simon Commission in 1926. A large number of political parties boycotted the Simon Commission because there were no Indian representatives on that commission. But eventually that commission gave a report. Then the Round Table Conference happened in 1932, which was attended by Mahatma Gandhi, and post that the result was the Government of India Act of 1935. And that act established a federal structure which eventually culminated in India. Under that act, there were provincial governments and there was a central government. So there was a central legislation and there were provincial legislations in 5 provinces: province of Bombay, province of Bengal, province of Madras, central provinces, and north provinces. So there were legislatures in these states and there was a central legislature. So the elections were held under the 1935 Act in these provinces. a federal court was established under this act, which was the precursor to Supreme Court in 1937. And that is how India was ruled between 1937 and 1947. As you all know, there was a mission known as Cripps Mission in 1945 for transfer of power to India. And pursuant to that, eventually the power was transferred on 15th August 1947. But before that, the recommendations, the various commissions were there, and they passed two acts in British Parliament. One was Indian Independence Act of 1947, under which two dominions were created, India and Pakistan, and abolition of Privy Council jurisdiction. So since then, the jurisdiction of Privy Council was abolished and federal court became the final court. So that happened on 15th August 1947. But before that, when elections were held in 1946, the body which was elected, that is the Provincial Assembly, that became the Constituent Assembly of India. And that body functioned from July 1946 till 26 November 1949. 26 November is the date on which the Constitution was signed. It was adopted, and that's why you will find that date in the preamble of the Constitution. We adopt, enact, and give to ourselves this Constitution, this 26 November 1949. But the Republic Day was postponed to 26 January 1950, and there's a reason for that. In 1929, there was a Congress session held at Lahore, and that session, the Congress had declared what is known as Purna Swarajya Resolution, and in that was adopted, the day was celebrated 26 January 1930. And that is how that Purna Swarajya Day became 26 January 1930, and therefore for enforcement of the full Constitution, 26 January 1950 was chosen, though the Constitution was adopted and completed on 26 November 1949 itself. And that is why we celebrate 26 November as the Constitution Day and 26 January as Republic Day. So post that, we have Constitution of India and Supreme Court. And thereafter, from 1950 till today, you need to study the history of Supreme Court to study history of India. And that I would divide in 2 minutes in 4 phases. The first phase of Supreme Court from 1950 till 1971, or 1977 rather, where the Supreme Court was a protector of fundamental rights. A large number of laws relating to land reform, etc., were set aside by the Supreme Court. So that was the first phase, the confrontation between the judiciary and the legislature, and that's how every judicial decision resulted in a constitutional amendment starting from 1950. The first constitutional amendment came in 2 months of the Constitution coming into force in June of 1950, and that is how up to 42nd Amendment, every judicial decision resulted in one constitutional amendment. That gave rise to Keswanand Bharati famous decision in 1973 relating to 25th Constitutional Amendment. That history you need to study. Eventually, over a period of time, you will study that. So that's the first phase of Indian government, Indian Constitution. The second phase, which was the liberalization of the Supreme Court judgments, that started from 1977, all the public interest litigation, concept of state, concept of Article 14, evolution, etc. That is a phase between 1977 and 1991. And during that time, the PILs, the Supreme Court's activism was related to personal liberty, bonded labor, inmates of prisons, etc. All judgments relating to personal liberty between 77 and 90. Post 91 till 1996, there was an era before Supreme Court where PILs and the litigations were entertained in respect of integrity and rectitude in public life. That's why this Jain Hawala case, etc. And post that, it is the environment and ecology. And the 3 principles, polluter pays, precautionary principle, and the intergenerational equity, these are the principles evolved, accepted by the Supreme Court in environmental and ecological matter, and that phase, I would say, continues. Post, of course, 2014, as a new phase where property rights are again recognized by the Supreme Court as a human right. So if you study the judgments of the Supreme Court, that is the study of history of India, particularly in relation to evolution of law. So that's broadly what is before you as young lawyers when you start legal practice. And that's the world in which you are about to enter, you will enter over a period of time, and welcome to that world. I would only conclude by saying that the legal system and judiciary was described by Lord Denning as oxygen in the air, and its importance you do not realize until it is withdrawn. Like oxygen, you do not realize until it is withdrawn, you take it for granted. To maintain that judicial system and legal system is the responsibility of lawyers and judges, and it is the responsibility of the well-read and the future citizens of this country, that is your generation, Gen Z or now Gen Alpha or whatever generation. So that's your responsibility. And I would conclude by quoting what Rabindranath Tagore said in a convocation address in Vishwabharati. Of course, that was a convocation address. This is a welcome address, not convocation address, but I would still say that. He told the students that you have learned here for 5 years or 4 years, etc. Now you will go to the world. You will represent us in the world. You will face problems in the world. Do such acts and deeds which will make us proud. And he said in Bangla, Ei amar Guru Dakshina. That is, this is our Guru Dakshina. That's the Guru Dakshina to make India, Indian society, a society supported by rule of law. You know the motto of Supreme Court, Vishwa Dharmasya Jagata Pratishtha, that is, the rule of law is the foundation of the universe, and you are going to be the architects of that foundation and that universe. Thank you.
Thank you so much, sir, for sharing your words of wisdom, and not just the perspective, but also long after this session, your words will be truly inspire us and look at law with a greater purpose and responsibility. As we come to the close of today's induction ceremony, I now invite respected Registrar Dhanaji Dadav sir to propose a vote of thanks, followed by a brief announcement. A group photograph of each batch will be taken with our honorable chief guest near the entrance of COE building. I request all the students to remain present and cooperate with the same. Thank you.
Dignitaries on the dais, most valued invited guests, and dear students. It gives me immense pleasure to propose vote of thanks of this induction function 2026. At the outset, on behalf of Maharashtra National Law University, Chhatrapati Sambhajinagar, I express my sincere gratitude and thanks to Shri Dr. Milind Sateji, Advocate General, Government of Maharashtra, for sparing his valuable time and sharing his expertise and experience. In his entire address, he has bridged the gap in between the traditional education system to the recent education system driven by artificial intelligence. Sir has aptly referred an era right from 1987 when the computers were newly introduced in school and colleges. There was no internet. There was no option of entertainment, neither reels nor Instagram, except library and newspaper. We used to write an assignment of 30 pages to 100 pages because to produce instant assignment, there was no chat GPT. The entire aim and objective of education is to turn mirrors into windows. And of course, as an institution of an importance, and as a sensible institutions to drive the force in the young generations, we will not refrain from the ground realities that the objective of education is to place the student at the better stage of life with opportunities and avenues. Once again, I thank Professor Dr. Lakshminath sir, Distinguished Professor of University and Officiating Vice Chancellor, for his valuable guidance and words of wisdom. I take this opportunity to specially thank Amarjit Singh Girase, who has witnessed the progress movement of these institutions right from bricks to bricks. Thank you very much for your valuable time and gracious presence. Once again, I thank all my faculty members, those who strenuously work hard for making success of this function. Once again, I thanks to all the students. On behalf of Maharashtra National Law University, let me put it on record that you are in the safe hand. We are here to provide you the wings to fly in the high sky. We are ready to walk with you. We are ready to talk with you. We are ready to provide colors for your dreams. Thank you very much.